In the trademark office, broadly speaking, there are two types of trademark applications. One is for marks you're already using. So if you have a product or a service, or maybe the brand name of your business, and you want to protect it, that's the application you want to use. In addition, there's another category of marks, those that you might intend to use in the future or that you want to reserve. And that's a different kind of trademark application. Legally, these are called intent to use applications. In the E5 trademark system, or with trademarks made simple, we call these reservation trademark applications just because the name describes what it is. In my experience, marks that are actually being used are much easier to register. Now, the standards that are applied are supposed to be the same between marks that are in use and marks that you wish to reserve. However, the examiners are humans too. And the natural inclination of anybody in the trademark office will be to give a preference to marks that are actually being used because they're more easily understood. Because you're using them, the examiner doesn't have to guess about what the mark will be applied to. They don't have to worry or have a concern that you are going to misuse the mark or try to counterfeit or go squat on a mark. And because their confidence level, even subconsciously, is higher, they will view the applications for marks that are already in use more favorably than those that you wish to reserve. That's not to say you shouldn't try to reserve a mark. Let's say that you are producing products and you do want to go to market on a particular day. You do have what we call a bona fide intent to use that mark. In that case, using a reservation application will be a quick and easy way to go ahead, get in a first in line position at the trademark office, and then in the examination process, you will go through the examination process in a sense twice. What happens is you complete the first half of an examination prior to your use of the mark, and then once you're using the mark to sell your product or service, there is a second examination that takes place just to make sure that your application is consistent with your use. So with a mark that you are already using to sell a product or service, obviously both of those pieces can be examined at the same time. So if you want to reserve the mark prior to selling the product or service, then the intent to use or reservation application is right for you. If you're already using the mark, then the mark for a use in commerce application is more appropriate. And if you're close to the point where you're going to sell a product or service, work with your attorney to make sure that the brand name you've selected is right for you. And then my recommendation is almost always to go ahead, use the mark, and apply for the registration on or about the same day.